Okay, sir.
All right, court come to order. Court calls case number 608-488. State of Texas versus Elaine V. like Victor Carrillo. State ready?
State's ready.
Defense,
Ready, Your Honor.
you've submitted a motion of affidavit of surety to surrender pursuant to statute. Have you given notice to the defendant?
Yes, Your Honor.
And how did you give that notice?
Your Honor, she was present on the previous hearing where I also withdrew as counsel on her case. And she was aware on that date in open court that I had filed this, the surety to surrender the bond on that date, Judge.
All right, then based on your motion and having given notice, the court will issue a warrant to capias for the arrest of the defendant, setting a bond at double the current bond. And upon arrest of the defendant, then the surety will be released, but not until such arrest.
Yes, Your Honor.
Your Honor,
Yes, ma'am.
just to let the court know that the defendant already has an active warrant since December 1st, 2020, and it is remanded without bond.
All right. Well, we're granting this specific order based on the affidavit of surety to surrender. All righty.
Judge, did you want me to share the order that I have? Did you want to look at that before? Is there any,
I don't know what it says.
would you like me to share it, Judge?
If you can.
Just give me 1 second.
That's it, sir.
Okay, there you go. Thank you. I wasn't able to do it online. That's correct.
All right. If and when you need to do it again, that order is not sufficient, or will I accept that? And for the sake of grammar, the first sentence, the first letter, the first line, the last word should be "and," not "and." You see that?
Yes, Judge.
And the second line, numbered cause, strike the D. And grammatically, removing the movement, surety, and bondsman, and strike "and to be released from his obligation of surety and above style number cause." Now, for me, some other judge might accept it. For me, it is not acceptable, because you have, under the statute, you cannot be released from liability until you've surrendered the individual. That is, that the individual is arrested. Once that individual is arrested, you can go ahead and be released, but not otherwise. And what you're saying here is issue a warrant and cut me loose regardless of whether the defendant is arrested or not. That's not acceptable. You heard what I dictated a moment ago.
Yes, Judge. Upon arrest, then I would be released from the obligation.
It is
Understood.
preceded by order the judge decreed that the clerk of the court issue an alias capias for the defendant in the above style numbered cause, no D. Anyway, you need to, that order is not acceptable to me. It should not be acceptable to any other attorney. But subject to that, the order I've dictated is what I will sign.
Thank you, Judge.
Okay, Patty? Patricia?
Yes, Judge.
All right. Thank you, Mr. Lara.
Thank you, Judge.
Be safe.
You too.
Patricia, what else we got this afternoon?
Your Honor, I've gotten several phone calls and text messages from Attorney Leslie Sakanowitz. And anyway, he wanted to explain to the court why he and his client weren't available at 9:30 and 10 o'clock this morning. I have him in the waiting room right now.
I'm here. I'm listening.
Okay, I'll admit them.
I want to know. Well, I'll ask. I've got some questions for him. Go ahead.
Judge, do you want me to go on the record since we're
Yes,
on you?
ma'am. Yes, ma'am.
Hello?
Yes.
Okay. Am I,
Hey, Luke, we can hear you, Luke, but we can't see you.
What are your cases, Mr. Sahanovich?
Yes, it's Mr. Luke Norby. They're two DWI cases.
605-052 and 629-944.
That's correct, Your Honor. That's correct, Your Honor.
They were called this morning and there was no response.
I understand, Your Honor. My
And
apologies.
we are on the record.
Understood, Your Honor. Your Honor, my apologies. I forwarded the wrong email to my client. I forwarded the email about the reset, so that so it's on me. It's my fault. And also I was stuck in the 186 and I couldn't get out. I couldn't leave this morning, Judge. So my apologies to the court. It's my fault for my client not being there, and mea culpa.
You had not, don't we, Ms. Garcia, don't we give notice to both state and defense, including the defendant, when we set matters?
No, Judge, when the defense attorney emails me to let me know they've got an agreement or reached an agreement with the DA, they don't 100% always give me the defendant's email address. I tell them they need to give it to the state, and then I email or I send out the notices to the defense attorney.
All right, but did you, as a coordinator, give notice to the defendant?
No,
Luke
sir.
Austin Norby?
No, sir.
All right, I want to visit with you on that later, but, all right, so, Mr. Sahanovich, is your defendant with you right now?
He is, Judge. He should be on there.
I see him.
Yeah.
He's on the screen. What says the state? Are you ready to proceed now, or you want to reset this?
We can proceed now, since everybody's present.
And what are we doing on these two cases? It's a plea, I understood.
Yes, sir. The plea is for regular supervision in each case to run concurrent. And as part of the agreement, the state will take into consideration and dismiss a felony case. As soon as we finish here, I will alert the felony ADAs and they will tender their dismissal form to their judge.
All right, give me a moment. I was attending a judge's meeting, came right into this proceeding and didn't realize I had not put my robe on. All right. On cases 605-032 and 629-949, are you Luke Austin Norby?
Yes.
Are you the same Luke Austin Norby that was charged with DWI said to have occurred on January 2nd, 2019?
Yes.
Are you the same Luke Austin Norby that was charged with DWI said to have occurred on December 21, 2019?
Yes, Your Honor.
All right. Mr. Norby, raise your right hand. You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, put your hand down. Mr. Norby, we need to talk about several things. They will apply to both cases with some minor exceptions because they are two separate cases. In each individual case, you have a constitutional right to remain silent. That means that you don't have to make a statement on either case. You don't have to answer questions on either case. You don't have to submit paperwork on either case, especially paperwork that admits or confesses to wrongdoing. Do you understand you have that right?
Yes, Your Honor.
Are you giving up that right freely and voluntarily?
Yes or
Well,
no?
Mr. Sahanovich, I recommend very strongly right now, I'm going to put you all in breakout room. I suggest that you review the paperwork with him. I don't want indications of doubt or lack of knowledge about the rights and everything else that's going to happen in this proceeding. I'll give you a few minutes to do so. Patty, put them in breakout, please.
Thank you.
It's breakout room 2.
And Patty, I believe I sent you the documents for both of Mr. Norby's cases.
Affirmative.
After this, since we're all together, do you think it would be possible to get David Wheeler in so that he can approach the judge on his motion for continuance?
Did he file another one?
No, he didn't file another one.
I don't know what you're talking about. That was granted, and that's why it's moved for tomorrow at 1:30. The motion to suppress.
Then yes, he did file another one.
Okay. Today?
Looks like it was submitted on the 16th and accepted on the 17th.
Yesterday. All right.
And he sent an email to you copying me and Morgan at 1:23 p.m.
all right. I'll ask him to join us. What time, Andrew?
What
No.
time, what?
Ask him to join us. An hour?
20 minutes?
I'll tell him 30. Andrew,
Yeah,
Mr. Wheeler said that he's in with other clients on Zoom with other clients that are from out of town, and he'd be able to log on after 3, a little bit after 3 o'clock.
okay.
Your Honor, Judge,
Yes.
everyone's present. We're ready to proceed.
Mr. Sakhanovich does not appear to be present.
I don't see him, but maybe he's side there. Les, are you back? There he
There
is.
we go.
Just playing peekaboo.
All right. Then the court will come back to order on cases number 605052 and 629949. No, pardon me, 944. Mr. Norby, have you had a chance to review the documents with your attorney?
Yes, and I just want to apologize again. I'm sorry. I'm just nervous about this whole court.
All right. Back to the first question I had asked you. Do you understand you have a right to remain silent?
Yes, Your Honor.
And are you freely and voluntarily giving up that right?
Yes, Your Honor.
All right. Now, you also have a right to a jury trial. That's where 6 people selected from the community would decide whether you're guilty or not guilty. You have the right to cross-examine any witnesses who would testify against you if there is a trial that uses witnesses. You also have the right to have this proceeding in the public courtroom. You also have a right to appeal. A right of appeal means that either you individually or your attorney individually or the 2 of you together could demand that a higher court review this proceeding and the evidence for whatever challenge you wanted to make. All those rights you give up by entering into a plea bargain with the state. Do you understand that that's going to happen in this matter?
Yes, Your Honor.
All right. Now, you and the state both have a right to demand that this matter, this hearing, this plea be done in public. It is going to be put on the YouTube, the computer, because we're doing this by video conference due to the COVID pandemic. Now, are you willing to give up the right to have this in the public courtroom and proceed by video conference on YouTube?
Yes, Your Honor.
All right. The first document we're going to show you, you'll see it on your computer screen. In each of the documents, it's going to start off with the case number. These will be 605-052. The second one will be 629-944. In each case, we're starting with 605-052. The information at the top of each document, with one exception, will have that information, the case number, the state of Texas versus Luke Austin Norby, and then in the county court at law number 5, Bexar County, Texas. Do you see the information I'm referring to?
Yes, Your Honor.
All right. This particular document is named State's Consent to Video Conference. That title of the document is in all capitals, bold print. This one has the signature of the Assistant District Attorney, Mr. Andrew Harris Edelman, wherein they agree to do this matter by video conference and is being shown on YouTube. The next document now that's being showed to you has the same information repeated on this case, your name, court number. And this one is titled Discovery Acknowledgement. This particular document refers to a law named Article 39.14 of the Code of Criminal Procedure. That law requires the state to share and acknowledge to you the information, documents, witnesses, all the information necessary for you and your attorney to make a informed decision based on the information required by law. Do you see the document I'm referring to?
Yes, Your Honor.
This one is signed by your attorney and the assistant district attorneys, indicating that they agree that this law has been respected and abided by. The next document will be yours, where this is your consent in writing to the video conference that we talked about. Do you recognize it and see your name on it?
Yes, Your Honor.
All right. And if you have not, you will sign this document. Did you already sign it? Do you know?
I did not.
Okay. But you agree to sign it. You understand what it says.
Yes, Your Honor.
The document before you now, again, with the introductory information, this one is titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It starts off with 3 individual sentences. The first one, you're saying, I don't need to have you, the judge, read to me what the papers say, the official documents that accuse me of driving while intoxicated. In fact, the second sentence says, I know that I'm charged with driving while intoxicated. The third sentence says, I hereby enter a plea of nolo contendere, which is no contest to the charge of driving while intoxicated. Do you see those 3 sentences?
Yes, Your Honor.
Do you agree with all 3 of them?
Yes, Your Honor.
All right. Now, the rest of this document is divided into 15 sections or divisions. They are all numbered 1 through 15. Number 1 talks about the range. Well, in number 1, all of the little squares that are stacked vertically have a declaration next to them about the range of punishment for the particular offense involved. The first little box is check marked. That means that you acknowledge and you are aware that the punishment for DWI first is a fine from 0 fine, that's no fine, all the way to $2,000, and jail from 72 hours, that's 3 days, to 180 days. Did you see and understand that?
Yes, Your Honor.
All right. The rest of the paragraphs, they're all 2 through 15. Number 2 is particularly important because it repeats in writing particular rights and constitutional protections that you have: the right to a jury trial, the right to cross-examine witnesses, and the right to remain silent. You freely and voluntarily given up those rights?
Yes, Your Honor.
Okay. Number 3 is a document or a paragraph or a section that talks about whether you have had mental health issues in the past, or mental illness. Have you ever had mental illness issues?
Yes, Your Honor.
And when was the last time you saw a doctor or somebody in the profession regarding that?
Whenever I was in treatment,
And when was the last time you were in treatment?
I want to say about a year ago.
All right. Are you taking medication for that right now?
Yes, Your Honor.
What is the medication that you're being given?
Depakote.
Say again?
Depakote.
Depakote? Okay. Do you believe it affects your ability to think and answer questions?
No.
All right. Number 4 talks about the plea of nolo contendere. I will inform you that nolo contendere in this court is taken as a guilty plea. Do you understand that?
Yes, Your Honor.
And you're saying here in number 4 that you're entering a plea of nolo contendere after you have reviewed the evidence with your attorney and listened to his advice. Is that correct?
Yes, Your Honor.
All right. Have you ever been involved with the sex offender registration program?
No.
All right. Number six tells you that you're entering a plea bargain agreement with the state. You need to know and understand that the plea bargain agreement has to be approved by me because I have the authority and responsibility to approve it or reject it. I also have the authority and responsibility to give you your punishment, which I can do within the range we talked about a moment ago, even if I give you a punishment heavier than what you agreed to. But if I reject your deal, your plea bargain, or if I give you a punishment that's greater or heavier than what you agreed to, the law would allow you to start all over again, and nothing you've said or signed would be used against you. Do you understand that?
Yes, Your Honor.
Number 7 simply says that if your attorney has filed pretrial motions and I have ruled on them, and you believe that you want to appeal that, you can do so only if I have ruled on them. If you haven't, then you will not have a right to appeal. Where were you born, Mr. Norby?
I was born in Belleville, Illinois.
All right. So I am noting in the file, in the record, that you are a U.S. citizen.
Yes, Your Honor.
The rest of these things, did you look at them closely? And this is a regular probation, Mr. Edelman?
On each case, yes, it is, sir.
Okay. Mr. Norby, did Mr. Sahanovich carefully explain the rest of these to you?
Yes, Your Honor.
All right. Number 15 in particular, I want to address with you. It says that you have the right to have me have a risk and needs assessment for you. Now, I'm particularly concerned because if you've had mental health issues, it might be important that I have a risk and needs assessment done for you to see what we can do to help you. Or if you need help. That's why it's called a risk and needs assessment. Now, signing this document says that you don't want us to do that, but I want to ask you up front, do you want me to do a risk and needs assessment?
No, Your Honor.
So you want me to proceed on this matter, on both of them?
Yes, Your Honor.
All right. I note for the record that you have answered number 15, that you're waiving that right, and that you and your attorney have both signed this document. The next document I'm showing you now is this is my certification, my declaration. It's titled Trial Courts Certification of Defendant's Right of Appeal. There is a stack of little boxes vertically stacked, and next to each box, there's a declaration, a statement concerning your right of appeal. This particular one, the fifth box, I am marking, and I am certifying to you that this is a right of appeal statement by the court, certifying that because this is a plea bargain, you have agreed to waive and acknowledge that you have no right of appeal. Is that understood?
Yes, Your Honor.
All right. And in fact, it has the signature of your attorney. I believe you have signed the original, or you're going to, is that correct?
Yes, Your Honor.
All right, this next document with the information at the top is titled Application for Deferred Adjudication. I thought this was a straight
It should
probation.
be straight probation, Judge. Should be application for community supervision.
All right, well, that needs to be corrected, or you need to do a new form. It says application for deferred adjudication. This is not a deferred adjudication case, Mr. Norby. What this says, what probation is simply that the court, after we've completed your plea on nolo contendere, I will find you guilty, and then I will sentence you to jail as part of the punishment, but I will suspend that. And I'll suspend it on condition that you live up to 100% of the conditions of supervision. That is a written, legal, binding agreement between you and this court. Is that understood?
Yes, Your Honor.
All right. If you violate the conditions, that is by either failure to live up to 100% or by refusal to live up to 100%, either one. If that happens and the state asks me to give you notice and bring you in for a hearing, if the evidence supports it, then what we'll do is put you in jail for the amount of sentence that we're going to assess, or we're going to give you here in this case. Is that clear?
Yes, Your Honor.
All right. We don't want to do that, right?
No, sir.
Okay. When you signed this document earlier, did you know and understand what you were telling me about this document under oath?
Yes, Your Honor.
Okay. This form is not filled out. Mr. Sahanovich, did y'all fill one out sometime today?
We'll get it filled out, Judge.
Sorry,
We'll get it filled out, Judge.
it is?
No, so we will fill it out today. Sorry, Judge.
All right. So, Mr. Norby,
Yes. Yes, Your Honor.
you and Mr. Sahanovich will do it as an order from the court, and he's an officer of the court. You need to fill this out completely, including the names and addresses, etc., relationship on the three references that will always know where you're at. Is that clear?
Yes, Your Honor.
All right. Have you ever served in the military?
No.
All right. And are you single or married or divorced or separated?
I'm single.
Do you have any children?
No.
All right. Okay, to the charge of DWI misdemeanor B, how do you plead, sir?
Let's see. Guilty? Or Nova?
No contest?
Yes.
All right. That means that you're not opposed to the charge without entering an official statement or declaration that you are guilty. The court accepts your plea of no contest, and I find you guilty. Now, The document before you is titled at the very top, plea agreement. And it's a little different at the top then, because below that it says State of Texas versus Luke Austin Norby, and it says case number 605052. The first two boxes I will fill, because the first one talks about that I have explained to you and discussed with you the right to remain silent. The second one is that I will mark says that you are a U.S. citizen. Then you have the following section is titled Defendant's Acknowledgements. That means you know and understand, and you're telling me that you are understanding what it says there next to each of these 5 boxes. Is that correct?
Yes, Your Honor.
All right. The state is going to proceed with the DWI as originally charged. Then down the line, it says you're pleading nolo contendere, and we've already done that part. Now, the punishment. We are finding you guilty. You're sentenced to 6 months Bexar County Jail. That is locked up for 6 months. However, I am probating that or suspending it for a term of 24 months. That's 2 years. You will be fined $400. And if you live up to all the conditions, if you do what you're supposed to, you will not have to pay any of that. But you gotta show me, you gotta do it first. You'll have to do 96 hours of community service restitution. If you behave yourself and you follow the rules, half of that 96 hours, which is 48 hours, will be forgiven. But if you screw up and mess around and you violate the conditions, then you're going to do the whole 96. Is that clear?
Yes, Your Honor.
You're also going to do the APSE classes. That's the anger management class, okay?
Okay.
All right. Now, you will have to, in good faith, enroll in and complete the DWI intervention program, the DWI Victim Impact Panel Live. You'll have to submit to a TAP TAIP evaluation and follow the recommendations. You'll have 12 months of ignition interlock on your vehicle. Is that clear?
Yes, Your Honor.
And you're not to drive any vehicle other than your vehicle with the with the ignition interlock. Now, this case, the punishment will run concurrent with case number 629944. Is that clear?
Yes, Your Honor.
All right. Your supervisory fee, are you working at all?
Currently, not right now. I've been in and out of jobs.
Say again?
Currently, I'm not working right now.
When's the last time you worked?
I worked back in February. Last month.
Last month? So what were you doing and how much were you making?
I was doing fencing. I was making roughly $12 an hour. It was for a friend. It just didn't work out.
And how long had you been doing that?
Did that for a couple weeks, and then prior to that, I was at Dunkin' Donuts.
What were you earning there?
I was earning $9 an hour.
All right. The court will set your supervisory fee at $25 a month. I am ordering you to make sure that you put your thumbprint on the judgment, the documents that required on this case and on the following case, both. You have within 7 days, I want you to go over to the courthouse, go around back of the courtroom and tell the staff there at County Court number 5 that you're there to put your thumbprint on the documents. They will assist you. They'll probably get the bailiff to help you. Is that clear?
Yes, Your Honor.
You make sure you do that. All right, now court calls case number 629-949, pardon me, 629-944. Mr. Norby, this is basically an exact repetition of the previous documents on the other case. The punishment in this matter is going to be repeated like the other, and the expression is that they're going to run concurrent. That means they run together, and the same work and fines and stuff that you're going to do in the previous case, you're going to do in this one. Do you understand that?
Yes, Your Honor.
All right. The laws applicable and the protections and constitutional rights are the same. Do you have any question about that?
No, Your Honor.
All right. The right to have this in the open court, you're waiving that, and so is the state. Those are the documents. The discovery agreement or acknowledgement is the one that says that your attorney and the state have complied with the law regarding what's called Article 39.14. That's applicable just like the other case. The only difference is different in the charges on different dates and on different, the same charge on different dates. The plea agreement in this matter is the same as the other. You're entering a plea of nolo contendere, is that correct?
Yes, Your Honor.
You understand all the rights that we discussed previously apply to this particular case?
Yes, Your Honor.
All right. And ultimately, what is your plea in this case?
No contest.
All right. Again, a no contest plea is considered a guilty plea here, and it's sufficient for me to convict you. Do you understand that?
Yes, Your Honor.
You're going to have to put in your thumbprint on this one too. So when you go and you do the thumbprint on the other case, you got to do the same thing here. The punishment is the same as the other. The requirements, you live up to 100% of the conditions of supervision. You go and do the DWI intervention, the victim impact panel, all those same conditions as the other, they apply on this particular case, and you're required, including the APSE classes. All of these things are the same. That's why we're saying they run concurrent. They run together. And your supervisory fee will be $25 a month. When you pay for one, you're actually paying for both. Is that understood?
Yes, Your Honor.
Do you have any questions?
No, sir.
All right. Don't forget on this one too, you have to put your thumbprint on it. So you have within a week, the sooner the better, go in and put your thumbprint on the documents.
Okay.
Questions, Mr. Edelman?
Nothing from the state.
Question, Mr. Sahanovich? If you're trying to say something, you're muted. You're still muted.
Sorry, Judge, I have
There you
barking
go.
I have a barking dog in the background, so I put myself on mute. Have nothing further, Your Honor.
All right. Then,
Miss Luna?
Ms. Luna, you're going to meet with Mr. Norby?
Yes, I am, please.
All right. Mr. Norby, if you wish, Mr. Sahanovich, you can join him, but Mr. Norby, you'll be required to visit with Ms. Maricela Luna. She's the court liaison officer that's going to set you up for the probation, give you the information that you need and the instructions to follow. Is that understood?
Yes, Your